welcome to Ask Tim, the insurance technical podcast brought to you by iAbney. I'm your host, Tim Dodge, and I'm coming to you today from the Geek Cave, deep within the confines of iAbney headquarters in DeWitt, New York, and I'm just testing my reflexes and my motor skills here. You know, not getting any younger and gotta work on my reflexes, make sure they work okay, and just for kicks, let's see how good JB's reflexes are.
Ow! Tim!
Sorry, JB, hope you were wearing a cup. Anyway, enough with the motor skills. That's not what I'm here to talk about today. I'm here to talk to you today about no-fault insurance, about a change to the New York no-fault law that took effect early in the year 2011. It was a law that the legislature enacted before it went home at the end of the session in 2010. It was signed by Governor David Paterson shortly after that, and it took effect on January 26th of 2011. And this was a significant change to New York's no-fault law. Now, under prior law, before this change was enacted, if somebody was driving, operating a motor vehicle under the influence of alcohol or a drug, and they were injured, there was no-fault coverage for that person. Now, what that meant, practically speaking, you know, somebody gets hurt in a car accident, the ambulance is going to come, they're going to be taken to the hospital, they're going to be treated. The practical effect was that the person got medical care, but the people providing that medical care didn't get paid. And so healthcare providers and hospitals lobbied the legislature for a change to this law, and they got it. So now, under the new New York State law, an insurance carrier must cover necessary emergency health services rendered in a general hospital, and including ambulance services and related medical screenings taking place at the hospital. So, somebody is injured in a car accident, whether they're intoxicated or not, the carrier has to pay for the emergency health services that the ambulance provides, that the paramedics or EMTs provide, and that the hospital provides. When that person is taken from the scene of the accident to the hospital. Now, one wrinkle of this is that the carrier then has subrogation rights against the injured person. So if you're driving drunk or under the influence of drugs and you get hurt in a car accident, you're not completely off the hook for the bill. The insurance carrier does have the right to seek recovery from you, and I'm going to, with some restrictions on that I'm going to discuss in a moment. Now, the New York Insurance Department issued a circular letter on January 12th of 2011, circular letter number 4, and I'll have a link to that in the show notes, giving some direction to the insurance carriers about how exactly this is going to work and what the rules are and what their interpretation of the law is. First of all, they talked about what exactly the phrase necessary emergency health services means. And this is what they said. Services rendered by or under the supervision of a physician, paramedic, or emergency medical technician to treat the onset of sudden pain or injury and to stabilize the injured person if that person is then taken directly from the scene to a hospital. So, emergency health services provided by a physician or under the direction of a physician or a paramedic or EMT at the scene of the accident, taken to by ambulance directly from the scene to the hospital, and their services to treat the sudden onset of pain or injury as a result of a car accident. Now, one important feature of this is that coverage ceases once that patient is stabilized or when the pain or injury is treated. So imagine, for example, that I am driving while intoxicated, I get in a car accident, I get hurt. Coverage starts when I get hurt. And the ambulance comes and they treat me at the scene and they load me into the ambulance and they drive me to the hospital, and they give me some morphine or something for the pain, and perhaps I'm bleeding, they stop the bleeding, and so they get me stabilized. The second the doctor says, okay, you're stable, we're going to move you up to a room on another floor of the hospital, when he says that, coverage stops. The no-fault coverage stops at that moment. Now, what this requires the hospital to do, and the healthcare provider, is that they have to itemize on their bills which were the necessary emergency health services and which items fall outside that category, so that they can get reimbursed for the necessary emergency health services. Another important phrase in that law is that it covers related medical screening. Now, before the law changed, healthcare providers were well aware that if the driver was under the influence of drugs or alcohol, there was a good chance they weren't going to get paid for what they were doing. How did they solve that problem? By not testing for those conditions, by not screening patients for the presence of alcohol or illicit drugs in their bloodstream. This law requires the carriers to pay for related medical screening, so physicians no longer have an incentive to skip those tests. Theoretically, this should result in more appropriate treatment for the injured person. So they know they're going to get paid for these tests, they're going to do the tests now, and treatment will be rendered in a more appropriate fashion, which should result in better health outcomes for the injured person, and you would think in the long run would tend to hold down at least costs in some cases because the person has received appropriate medical treatment early on after the accident. Now, as I mentioned earlier, the carrier has the right, they have subrogation rights. They can recover from the injured person the amounts that they had to pay the healthcare providers for these emergency health services. But they have that right of recovery only if the intoxication or the influence of drugs were a contributing cause of the accident resulting in the injury. Example, I just gave the example where I'm driving and I had a bit to drink and I crashed into a phone pole. Clearly, I mean, there could have been an animal that ran in front of the car or something, but clearly the fact that I was driving while under the influence of alcohol has something to do with that accident. In this case, the carrier would have subrogation rights against me. Contrast that with me stopped at a red light after I've had a few beers, and somebody comes up from behind and smacks me, giving me whiplash, and maybe my face hits the windshield. I've got a few injuries here. Now, in that case, I was stopped. I was sitting at a red light. So it would be very difficult to argue that my having consumed a few bottles of beer had anything to do with that injury. The injury was caused by the person who struck me from behind. In that particular instance, even though I was intoxicated, the carrier would not have a right of recovery against me. So that's an important thing to keep in mind if you're a carrier attempting to recover some of these expenses. Now, also, because of this subrogation right that's built into the law, the carrier has the right to subrogate directly against the injured person's health insurance carrier, assuming that person has health insurance. And the health insurance carrier would then owe restitution to the no-fault insurance carrier, unless, of course, the health plan excludes coverage for this sort of situation where you're operating a vehicle while intoxicated. So it's going to vary somewhat from the terms of one plan to another. Even then, I can't make a blanket statement that's saying, yeah, if he's got health insurance, then they're going to be reimbursed by the health plan. It may happen, it might not, depending on the terms of the plan. For more information on this, I am going to have a link to the circular letter in the show notes, so make sure you check the Ask Tim blog and you'll find that link. You can find information on the auto insurance page in the research section of our website. Drag your mouse over the member resources link, click on research and guidance, and you will be taken to the IAVNI Research Library. From there, you'll see a link to auto insurance issues. If you want to get in touch with me, you can call at 800-851-8853, extension 229. You can email me at tdodge@iavni.org. You can fax me at 888-432-0510. You can find me on AOL Instant Messenger on those days that I remember to log in as tdog4494. You can find me on Twitter as Ask Tim. And if you've been watching the HBO TV series Game of Thrones, some people there in that show communicate by way of Raven. No one's tried that with me yet, but if all else fails, give it a shot. And as always, if you want information and want to know more about what happens if you drive while drunk, don't forget to ask Tim.